about is predominantly commercial high street issues today. But basically, we all know that the high streets are in difficulty. I think we probably agree with that. But what I'm trying to do is weave in and have a very practical approach to maybe some issues that might come up if you're not familiar with planning. So basically what was happening is the government announced the Towns Fund. So that was lots of money going into the high street. So that's money, money, money. Planning regulations were massively deregulated as part of a government project called Project Speed. So basically the planning system is saying build, build, build. So they're very positive movements from the government. And of course it was only private law, when it intersected with the planning, that was saying, actually, hang on a minute, what's going on? So the Towns Fund, I don't know if people remember this, Boris announced it as shovel-ready local projects. You might have remembered that in 2019. But there was sort of a secret agenda, really, because the money was targeted at the red wall seats. And we did rather well out of it in the north. Lots of places got between about 21 and 33 million pounds. So places like Barrow in Cumbria, Bishop Auckland, Blyth, Carlisle, Darlington, Hartlepool, Middlesbrough, Redcar, Thornaby and Workington. And then the planning deregulation was the introduction from, firstly in 2013, for permitted development rights to change offices to residential. There's been a lot of this going on in London and it has worked its way up, and there's quite a lot going on in Newcastle. And then also the other three permitted development classes are flats on top of shops, commercial, the new commercial business and service, which is, we're calling it a super class E, where you can, in a commercial area, properties can really change between different uses without planning permission. And then there's a new class MA, which came in 2021. And this actually is where it's permitted development now to change from class E to residential. So the general view is the first three are perhaps encouraging development in the town centres or supporting investment, whereas what the market's now worried about is permitted development MA, which means that the commercial premises might go back to residential. So that's a concern that the market's articulating. So I'm just looking at the private law issues which intersect with planning. So you may have sites that have planning permission. The planning system is saying, yes, that's fine, build, build, build. But there are other private law issues which really everybody should be aware of when advising clients. So there's a few traps or a few issues that you really need to have your eye on. And I've put them into three different groups, but you see towards the end I've got some other issues that I've flagged up. So basically, there may be leasehold issues arise, restrictive covenants, right to light, so other private law matters which may be in direct conflict with the planning system. So this is just by way of example. This is a planning appeal that I did recently where a building was held on a very long lease from the University of Newcastle. The lease specified the permissible use classes, but by reference to the old use classes order. As people may be aware, there's a market restructuring in student housing in Newcastle, and some of the landlords are experiencing voids in their properties. So obviously the natural commercial decision is, well, I could look maybe to put other uses into my properties. And the planning system is putting a brake back on those types of cases. So an issue may arise where the lease doesn't allow a different use. So the planning system says, yes, you can change it. The lease says, no, you can't, or you have to go back and renegotiate with your landlord. And also recently, I don't know if people are aware, the nationally described space standards have been introduced, and they set quite large standards for new housing and conversions to new housing. So they can catch people out if you're trying to convert an existing building. The other issue is just with these long leaseholds, and the Airbnb model is obviously coming to the market, and in Scotland they've got new regulations for licensing, so you may have to check on the licensing situation as well. So this is one of the more recent cases, Shaviram Normandy Limited and Basingstoke and Dean Borough Council. This is quite interesting because it just ranges across all the different areas of legislation. It's a classic permitted development case. There was a purpose-built office block on long lease from 1985. It became vacant in 2013, probably just due to market pressures I would have expected, and went into disrepair. A potential purchaser came along and got the council confirmed on a prior notification that it was PDR. Do apologise, planners love these shortened versions. So permitted development rights for residential use. So Basingstoke and Dean said, you don't need plan permission to convert it to residential use. The investor bought it. They were probably a bit cock-a-hoop. And then, because it was on a long lease, surprise, surprise, it was actually the council that held the head lease. And the council then came back and said, we're the landlord of the said property, and actually we're objecting to its conversion because we want it to stay in office use. The reason the council gave is because they said that they needed the offices retaining in the town centre, and it's important to the economy and the future of the town centre that this particular building stayed in offices. The Upper Tribunal did actually grant this application because at the end of the day they decided, it was held that the restrictive covenant was of no practical benefit to the council as owner of the as freehold, because basically if it remained in office use it was just going to stay empty for forever maybe, but for a long time. So that's a classic case where a building may have permitted development for one use, but a private law issue will arise and it will stop that permission being implemented. Edgware Road, this is a really interesting case. It's a bit of a confession, but I quite like reading case law, but this is one of the most amusing ones in property law that I have read. So if you've got 10 minutes to spare, I would definitely have a look at this. I'll highlight the best paragraphs to go to. But basically, this is part of the Hyde Park estate in London. The applicant got planning permission for a pod-style hotel. Council were over them in, they were like, that's absolutely fine, fill your boots, get on with the development. The church commissioners didn't want a hotel going on, they were the freeholder. And it's a pretty honest exchange in court if you read it about what everybody thought about it. But the church commissioners didn't want any hotel in this particular building, but then they were honest enough to actually say during the case, particularly they didn't want a budget hotel, and particularly they didn't want a pod-style hotel. The original statement of case for the applicant said it would be a pod hotel and windowless. It would provide budget accommodation to cater for short stays. They then amended their statement of case and they described it not as a pod hotel, but as based on an integrated modular scheme to provide bedrooms with ensuite bathrooms fitted out to a very high standard. They also said the hotel would be of high quality with fully trained staff and quality finishes. I couldn't work out if the quality finish was on the staff or was on the furniture. Very confusing judgment. And then they confessed that actually it might have been a backpackers hotel. The concern that the commissioners articulated was they said that it would be compromised in terms of its service offering because it had no communal areas, no services, the lack of food and beverage. And also because it had no windows. But another objection that they had was that the hotel may be used on the basis of the Japanese model by salarymen too inebriated to make it home at night. So they raised, I think it's best to say, a very wide-ranging number of concerns about this particular project. The expert evidence was really interesting because basically, in the judgment, the judge says, I won't read out the names, but he had two fellows of the Royal Institute of Chartered Surveyors, and I know we've got somebody with those qualifications in the room today. He described them as very experienced valuers of central London residential property. However, neither professed to be an expert on the valuation of hotels. The applicant's expert said there was no material injury, so the loss was zero. The church commissioner's expert said that the damage to the wider estate was £40 million if the restrictive covenant was lifted. So as you can see, the experts were quite a long way apart. Basically, the judgment in this case, it was held that it did have planning permission to be a pod hotel. It was in the commercial area, Edgware Road in London. There were lots of other hotels in the area, so it was a reasonable user of land. But the Upper Tribunal did find that the ground the church commissioners ran, which was that if they allowed this to become a pod, a budget, a backpackers, whatever hotel, they had lost an important tool of their estate management, and that was of practical benefit to the church commissioners. So it was rejected on that basis. So other issues that may flag up, I've just sort of flagged these up and urge you to think about them. So for example, the planning system at the moment has very wide-ranging permitted development rights, where you can actually build on top of shops 2 stories high without planning permission. There are various criteria, but generally they're promoting that type of development. And of course, some of the neighbours may have ancient right to light, and therefore there may be a private law remedy to stop that development going ahead. And don't forget modern rights to light. I think we all focus on ancient rights to light, but don't forget buildings have prescriptive rights as well. So depending on what side of the fence you're on, you might want to check that out or try and mitigate it. The other issue I've just flagged up quite quickly is, of course, the Party Wall Act. I don't know what the people in the room's experience of the Party Wall Act is, but my experience is everybody tries to ignore it for as long as possible until they get caught out. I don't know if people are having more success in advising their clients that it's better if you address this issue very early on. So, of course, the Party Wall Act can cause you problems. You might have permitted development, you might have a planning permission, but if you can't build something, then you've got a problem. And of course, I think paragraph 22 of my written notes misses off some words. Of course, boundary issues. A landowner may well think they've got permitted development to do something. They've rung the builders up, they've managed to find one in the northeast, they're off on site. They haven't bothered with the Party Wall Act because they thought it wasn't that important. And then they find out there might be a boundary issue and a right to light issue on the property. So there are all sorts of traps that you can fall into. The other thing that councils are increasingly doing, I don't know if people are advising them, but I've noticed a trend where some councils are trying very hard to be development partners or even do their own development. And they do have certain powers to facilitate development under the Housing and Planning Act. So if your local authority or the acquiring authority have these powers, they can actually override private rights. So lots of developers are aware of this, or developers should be aware of this. And if you can get your local council on side to help you out, or if you can enter into a joint venture with them, you might be able to get rid of all these problems about private rights. At the end of the day, if you miss any of these, or the person on the other side, you've got everything under control, and you may end up in court and the person on the other side has missed them. This is, I love this slide, but this is the mess that we end up in. So it's just be very aware, take legal advice, take advice from chartered surveyors. Right to light is a very knotty issue. So I think very early on, if you're advising people, make sure that you've taken advice from all the relevant professionals before you decide on a cunning plan and a strategy, because otherwise, if you don't, you're going to end up in court. And I don't know, maybe you like going to court in the room. I'm always really keen to get really good advice early so that I don't have to go to court. So that would be my advice to you.